Thanks everyone for coming to Bridge Association of Realtors first town hall meeting. And when he gets here, I very much want to thank Gov Hutchinson for joining us at our first town hall. These have been strange days. I thought that the 2007-2008 short sale foreclosure years were going to be the weirdest years of my real estate career, but 2020 is really shaking that coil off. I can't tell you how many times in the last month I've seen something and thought, wow, I've never seen that before. I can hear the anxiety and the tension and the confusion from all the emails and texts and phone calls I get. I just want to assure everyone that we at the local association, everyone at C.A.R. on the state level, and everyone on NAR on the national level have been working hard, being your advocate, making sure that you're all protected, and trying to make it as easy as possible to conduct business in this really difficult time. Divina and I talk at least once a day. I'm in C.A.R. and NAR Zoom meetings and virtual town halls once or twice a week. I know that Kieran is working daily with local government, trying to make it possible for us to conduct business. I specifically want to express my gratitude for those who have stepped up, seen a need in our membership, and filled that need and helped us during these difficult times. I really want to thank Holly Bradford, who has set up the virtual brokers tour for Mondays and Thursdays. She saw a need and she filled it, all without any asking. She just put her effort forward, and I very much appreciate that. We'll all get through this together. Again, we're all working hard for you. Please feel free to contact me. I'm always here to listen and to try and solve problems if I can, or pass you on to the person who I think would meet your needs. Everyone stay safe and sane, and thanks again for coming to our first town hall meeting. Back to you, Divina.
Thank you. And I will tell you, excuse me, it's been a pleasure working with Eric. He's really been working very hard through all of this and putting in a lot of time and effort. And we've been working very hard in conjunction with the other two associations, Bay East and Contra Costa, since we share many offices together, and working in tandem to get the joint message out with the other associations because of the shared counties and cities together. And so you will see that the messages that we have gotten out together with the stay-in-place orders have been the exact same message, and we've worked together with our GADs in getting that information out. Our GADs have worked in tandem to reach out to the city officials to make sure that we are in unison together. And it may take a lot of time to get that answer, because we've been fighting together to make sure that essential businesses, that was clear to get that, to get the information was always a clear message, and so we weren't running back and forth and changing it and everything. So that's why I wanted to make sure Kieran was here today to explain the SIPs and the changes that were taking place, along with some of the other ordinances that we're dealing both in Berkeley and Oakland. So right now, I'm going to turn it over to Karen Shenoy. I'm going to ask Jake to unmute Karen Shenoy right now. Jake, I hope you can hear me, and you can unmute Kieran and have him give us an update on the stay-in-place order for Alameda, Contra Costa, and Berkeley, and let us know if there's been any changes. We've had several questions come up about stagers and photos and things like that. And then also let us know what also is going to be what's taking place in with some of the ordinances, because I know some of those are moving forward. Karen, are you on the call right now?
I'm here.
All right, let's get an update from you.
All right, thanks, Divina. Hello, everybody. Like Divina was saying, it's been a bit of a struggle trying to get clarification on these shelter-in-place orders for the past couple of weeks, and ever since the initial shelter-in-place order was issued back in mid-March, which you all know there was no, well, real estate was not deemed an essential service at that point. Then fast forward a couple of weeks, and then there was a declaration from the federal government that added real estate to essential services on the federal level, which was incorporated into the statewide order. At that point, it was incumbent on us and the associations in our immediate area to get together and try to seek clarification on the county orders, which control how we conduct business in Contra Costa County, Alameda County, and the city of Berkeley, because all three have their own separate public health departments. And so they all have their own shelter-in-place orders. So on March 30th, the Bay East Association, the Contra Costa Association, and us, we sent a joint letter to the Alameda County supervisors and the public health officer in Alameda County and Contra Costa County, as well as the city of Berkeley, to see if certain real estate related activities could be deemed essential, because they were deemed essential on the state level. And as all of you know, on March 31st, the counties and the city of Berkeley came out with a new shelter-in-place order, which deemed real estate as an essential service, and residential transactions could occur, but in a very limited scope. So after that occurred, it was just a matter of seeking clarification. Everybody had questions, right? So real estate transactions could go forward. Are title companies allowed to conduct business? Are the recorders going to be recording title? You know, are stagers allowed? Are photographers allowed? You know, what is a virtual viewing? If a virtual viewing, there are so many questions out there. So it became an exercise of seeking clarification. And at that point, it was a constant communication between all of our associations, the government affairs directors, and the county officials and the city of Berkeley officials to try to get clarification there. And we did. You know, it's been since clarified that home inspectors are allowed to conduct business, or an essential service. Appraisers are allowed to conduct business, and now photographers are allowed to conduct business in terms of residential real estate transactions within certain parameters, and always following social distancing protocols. So I'm not going to get into the weeds of it, and you can always email me with any question. I'll provide my email address here for you, just to clarify anything that you might have a question on. And so we have an ability to move forward and conduct business, and always remember that you have to conduct business in the counties of Contra Costa County, Alameda County, and the city of Berkeley under the auspices of the county orders, right? So all of the interpretation and the rules that you have to follow are the local ones that we are providing you guidelines with. So please always keep that in mind. And just a quick recap of what's going on in Berkeley, Oakland, and the surrounding area. Everybody is still, you know, open for business. BASO, if you guys know what BASO is, they're still receiving applications and allowing people to move forward with the audit process and get a time delay certificate on that. The same thing is true with the sidewalk ordinance. We've been hearing that they are still processing time delay certificates and provisional certificates for the sidewalk ordinance. The private sewer lateral ordinance, East Bay Mud is still doing inspections. You know, plumbers are deemed essential, so they're still out there doing work. Oakland permit offices are not open, but everything can be done via email or by giving them a call. So, you know, if you reach out to me, I've sent out a notice earlier this week about with all of the numbers and the links, but just reach out to me and ask me where to go for any of that information. Berkeley is not prohibiting photography. We've received confirmation, even though that their FAQ says no photography, we've received confirmation from the city attorney's office that photography is okay. And then, eviction moratoriums are all across the Bay and all across the state. And just like everything else, we have local laws that supersede the state level laws. So please, if you have a question, email me. I will send you the right information and the right place to go for all of your questions. And with that, I'll leave it off to Divina.
Thank you. Thank you so much, Karen. And we are going to have a Q&A here before Gov comes on board. But the last person I'm going to turn it over to is Gustavo. And he's going to talk about some of the things that are going on with the MLS, some great tools that could help you through the stay-in-place order, and also talk about the CLEAR cooperation rule that is still going to be taking effect come May 1st. Unfortunately, we did try to push on NAR to change that rule. Unfortunately, NAR is not budging. And so we are going to talk a little bit about that. So with that, I'm going to turn it over to Gustavo Rodriguez, COO.
Thank you, Divina. So good afternoon, everyone. So I'll talk about the open house first, because I know that this is a very important subject and topic for everyone, because since shelter in place, what we did was we disabled open house within the system, but we are going to open it up again, and we're going to open it up again tomorrow. And what's going to happen is that you're going to be able to enter an open house, but now you're going to have a field that is required to enter a live stream open house URL. So you can only have an open house virtually, and you're going to be able to do that. So what I'm going to do now, I'm going to share my screen, and you tell me if everybody can see it just fine. Let's see, hold on one second. And what you should be looking at right now, it's the breachmls.com website, and it reads live stream open house on Breach MLS. And that is the information that we have on this particular topic, which is the open houses. We know it's very, very important for you guys to, and for the business to actually have the open houses. And this is why we came up with this particular field that will allow you to have the open houses virtually. Like I said, it's going to be open up tomorrow, and the screen is going to look like pretty much the way that it looks right now before shelter in place, before we blocked it. You're going to be able to enter all the same information, the dates, the times, but now you're going to have a required field that is called live stream URL. So the live stream URL is required in order for you to enter a live stream open house. This open house is going to be searchable, of course, and the screen is going to look exactly the same as you are used to in the system to searching for open houses. The live stream URLs are going to be posted on your reports, so you're going to be able to see it on all the different reports, the client reports, and not only that, but you're going to be able to see that link fed into the third-party vendors or IDX. So if you have a website, if you are used to sending your information to a particular marketing tool that's outside the MLS, and you have a feed with us, with the MLS, that URL is going to be included in that feed into the outside world, so that it's viewable by the public. So that's with the open houses. So I'm going to leave the questions towards the end. I'm going to go into the next topic and talking about open houses and virtual tours and all of that. I want to share with you guys that we have an agreement with Box Brownie. Box Brownie, it's a company that what they do is, and I'm going to bring it up here on the screen. Let me just go back here. We're very proud to say this. We're the first MLS in the nation that have such an agreement with Box Brownie. And what Box Brownie does, it allows you to enhance the photos that you have. But more importantly, right now, it allows you to set up a virtual staging. Not only virtual staging, it also allows you to do 360 virtual staging and 360 virtual tours. It's a very easy to use tool. All you have to do is to go to boxbrownie.com, and what you do up on the very top, you click on free sign up, click on that. It's gonna ask you to enter all your information. You click on sign up, and that's it. You create your own password, you log in, and then you select whatever services that you want from Box Brownie, say the virtual staging, or you want the virtual tour. If you want any of those, you select it, and then before you make the payment, it's gonna ask you for a code. And what we'll do is, we're gonna send you, if you're a Bridge MLS member, we will send you a code that you can enter, and you will get a discount on that service. So for the email, for you to receive that code, send us an email to support@bridgemls.com, and we'll reply to that, and we'll send you back the code for you to get that discount on it. Now, let me just do this real quick, and I'm going to show you that we having webinars on Box Brownie as soon as this coming Friday at 10 a.m. from 10 to 11. We have Peter, who is actually based in Australia. He's going to be having a webinar on this product. And also we have one on Tuesday, April 21st, from 1 to 2. All you have to do to register for the webinar, go into your member portal, select the class that you want. In this case, if you want any of these classes, just click on the link for the class, and it's going to allow you to register for it. I think it's an amazing and pretty cool tool, especially in the times that we're living in. So that is Box Brownie. I'm going to talk about Statement 8.0 that Divina was just referring to, and that is the Clear Cooperation rule that came out off of N.A.R. And as you recall, back in November of 2019, N.A.R. approved this rule to be implemented in the MLSs. And I'm just not going to go into the details of it because there's a lot of information on it, but basically what the rule says is that if you're marketing a property, either with a sign or with a flyer or with a marketing material, what you need to do, what you must do, is to enter that listing into the MLS within 1 business day. So that is the essence of the rule. The essence of the rule is that you need to contribute to the MLS in making it stronger, in inputting the information if you're going to be marketing the property to the outside world. So that is what the rule states. What you're looking at the screen, it's from the N.A.R. website. You can Google it, just N.A.R. Statement 8.0, or you can go to the NAR.realtor website, and that's gonna give you the details on the rule, and as well, it's gonna take you to the frequently asked questions, and you will see all the answers for all those frequently asked questions. So we're gonna be implementing this rule as of May 1st. That is when the rule begins to be implemented. A couple of more things that I'm going to talk about, and I know that we have a tight schedule on it, and so that I can let Sandra come in. I'm going to go into the bridgemls.com website. Please, if you have, if you want to know more about the MLS and things that we're doing, because we're constantly changing things and upgrading things in the system, going to bridgemls.com, going to news, and Bridge MLS News, and that's going to give you a list of all of the different things that we're working on and the things that are coming to the MLS, just like the live stream open house that is coming on tomorrow, and the coming soon listing status for all property types that is also coming in tomorrow. So as of tomorrow, you can go into the system and actually enter a coming soon listing within each property type. So So we want to have a coming soon status within each property type. And the nice thing about this is that when you're ready to make it active, you will be able to simply transfer that data from coming soon into active. So you don't have to re-enter the information. So coming soon status is going to be available for you as soon as tomorrow. All right. Something else that is very important on the breachmls.com website, it's our training center. If you're going to member benefits, going to events and training, click on that, and that's going to give you a list of all the different classes that we offer. And if you want to register to any of the classes, all you have to do is to click on the class itself. It's going to bring you to the details of it and a link to register to the class. So there's a lot of things going on in the MLS. Please send us any questions to support@breachmls.com. You can also send me an email. My first name is Gustavo. That's Gustavo @breachmls.com.
Gustavo, if you would be so helpful as to type your email into the chats, I'd greatly appreciate it.
Sure.
So we're going to take some questions, but I've seen some questions pop up that I want to address. If you can, we're going to have you stop sharing your screen right now. We'll come back to everybody. A couple of things on clear cooperation I want to make very clear, and I've gotten some emails on it, and I haven't seen Gov come in yet. Okay, he hasn't come in yet. I know he's dealing with another meeting, but real quick, in regards to there is a company out there called TAN, Top Agent Network, and I've been asked about that, if they comply, if putting it onto their system complies with 8.0. Once it is, a listing is on the TAN network, on the TAN product, I want to make it very clear, once it is posted onto TAN, you do have to comply with the 8.0 rule, and it needs to be on the MLS within the time that the 8.0 rule is in effect. So and I get confused, it's 48 hours, right, Gustavo, to be on our MLS?
That is correct. It is. Okay. It is within 24 hours.
Okay, 24 hours.
Yeah, within one business day, yes.
Within one business day. So if you are part of TAN Network, or you know somebody who's part of TAN Network, please understand that once it is posted on the TAN Network, it must be in the MLS if you are an MLS member within 24 hours, one business day. So, or with one business day. And I'm sorry, they've changed it a couple times on us. So that is very, very important. Now, if you have a listing, it doesn't have to go into the coming soon status if it's an active listing. But if it is a coming soon listing and you want to market it as a coming soon, then it needs to go into that status, whether it's active or coming soon. If you want to market it, you need to put it in there. So we will have all the detailed information coming out to you, really soon. We have been working on getting the system up and running and everything. So again, it will come in. Somebody asked a question, what if you have assigned SCLM? Again, as long, if you have an SCLM filed, that's great. You are following the rules, but the minute you market it to the public, the minute you start putting it out there, it needs to be in the MLS. Okay. So the minute you start marketing it to the public, that means outside of your office, you need to put it into the MLS. Okay. Other questions?
Could I say something on one of the questions that I saw in the chat?
And let's start raising hands if you want to not type it, you want to, Gov is here, but let's take a couple of questions. Raise your hand and we will look at questions too. About anything that we've talked about before. Gov will take a couple of questions. Go ahead, Gustavo.
Yeah, so I just wanted to address one of the questions that came on the chat, and that is that maybe some are getting confused between the coming soon status that we're having versus statement 8.0. They're two different things. Yes. The coming soon status that we have on within the system will allow you to have a listing within that status that is not for public showing yet, but within the MLS so that others can see it within the MLS.
Yes.
And that is something different. A coming soon listing can be in the system 30 days. So that will stay for 30 days, you know, unless you make it active within the system. So that has nothing to do with Statement 8.0. Statement 8.0, on the other hand, what it's saying is just what Divina has stated, is that the fact that you cannot send a property out to the public to market it without putting it in the MLS.
Right.
So you have one business day to put it into the MLS if you're marketing a property, regardless of the way that you're doing it. If you're doing it with a flyer, paper flyer, which right now nobody is, of course, or with the digital marketing, or putting it on your own website, putting it on Facebook. If you're putting it onto the public, then you must put it into the MLS.
So a couple of questions, we'll take these, and Mary, I see you, we'll get to you real quick here. Let me just take this. Does a coming soon status have a price? Gustavo, I'm asking you.
I'm sorry, what was the question again?
Coming soon status, does it have a price?
Yes.
Great. And next question is, if we put something on TAN, would it be in compliance if we put it into coming soon within 24 hours? The answer is yes. Can a listing in the coming soon status be sent to a client?
No.
Okay. All right, Mary, you had a question. Let's, if you can unmute Mary Canavan. Okay, good. She's good. Go ahead, Mary.
So is there any, you know, there's some things that the weekends don't count, you know, it's only.
It's one business day.
So that means that in theory, you could put your listing on TAN on Friday and then put your listing on the MLS on Monday. So, I mean, there's some place for somebody to game the system, right?
Well, you said it, not me. But
okay. I'm just checking if you know it's going to come up.
Yeah, yeah. So this was a big debate that we've had on the floor many times, both on the state and the national level, about the days. We fought it. We were trying to say one day. It went back and forth about business days, and that conversation did come up. Yeah. So again, we did not make the timing. It came down from the powers that be. Yeah. Right. If you're not ready with the price or publicizing address, can you put it on the MLS and a coming soon? Yes. All right, Gov Hutchinson is here. Do we have any additional questions? You guys ready to hear from Gov? Gov, we have you here. I'm going to introduce him. I know he's here somewhere. If we can unmute Gov. Gov Hutchinson is the Assistant General Counsel and Vice President of the California Association of Realtors. He's been with C.A.R. since 1985. Oh my God, I was like 5 years old then.
I know, me too.
Right, Gov? We're about the same age. And manages C.A.R.'s Member Legal Services Program in Los Angeles. He advises a realtor.
That's enough, Davina, that's enough.
Oh, I got to read this part because this is really what's been keeping you busy, the hotline. That's all I need to say because I talk to you twice a week and hear what you've been doing on the hotline. So with that being said, everybody doesn't care about hearing us. They want to hear from you, Gov. So I'm going to turn it over to Gov. Have fun, Gov.
Hi. Yeah, the legal hotline, believe it or not, is very busy. And we've also got this other hotline I think you know about, but I'll talk about it later when I talk about realtor relief stuff. We got the COVID relief hotline, and I'll tell you about some of the things that, excuse me, you guys are eligible for. But let me start with sort of legal stuff. As you can probably imagine, I do this last few days, doing this a lot all over the state. And of course, we're in this wonderful situation where what realtors can do and not do varies depending on where you are, depending on what county you're in, depending on what city you're in. Some counties are completely shut down. Some counties, you can pretty much do most things. Of course, we have the overriding state rule that everyone has to comply with. But anyway, I'm talking to Berkeley and I'm talking to Alameda County, which basically says, yeah, you're essential service providers that enable real estate transactions, including but not limited to, and they mention realtors. The question is that including but not limited to, what about inspectors and stagers and photographers? I'd like to look at that broadly, right? I mean, including but not limited to, you can say these people all enable real estate transactions. So unless there's something specific I'm not aware about in Berkeley or Alameda County specifically prohibiting certain people, I think that can be fairly broadly interpreted. But then it gets tougher and it says, provided that appointments and other residential viewings must only occur virtually, or if a virtual viewing is not feasible by appointment. Okay, so the next question, of course, is what does it mean to not be feasible? What would make virtual not feasible? I have no idea what that means. I don't think anybody knows exactly what that means. So in other words, you're probably going to interpret that kind of broadly too. So you're going to say, okay, it's not feasible, so we want to see the property. But then we have the problem that says in-person visits are not allowed when the occupant is still residing on the property. It's hard to interpret that any other way than to say you can only in person show vacant properties. That's true in many counties where you are. It's true in LA County, and it's not true other places. But you got to deal with the rules where they are. So it's hard to interpret that as any other way. The question I have is, well, is the limitation on only vacant properties, does that only refer to showing properties to buyers, or what about all these other things like inspectors and things like that? Are they also only allowed on vacant properties, or is that terminology referring to appointments and viewings only apply to showings of properties to buyers? And I'm sure you're all waiting for me to give you the answer to that question. And the answer is nobody knows. So once again, if you want to interpret it broadly, and unless someone in Berkeley has said otherwise, it could be interpreted to mean that people like inspectors and such can enter properties that aren't vacant. But as far as showing properties to buyers, assuming virtual is not feasible, it's pretty much got to be vacant. The next point is, who's ever entering the property for any reason, vacant or not vacant, under California law, the California order, you have to follow best practices. And in other words, that's the governor's order incorporated federal guidelines that we have translated into best practices. It's our position that this is legally required stuff. The things like no more than one agent and 2 other people at the same time, everybody wears gloves and a mask, et cetera, et cetera. Hopefully you've all seen the best practices and you should really try to comply with them. And to make it easier to comply with them, we have a couple of forms that we're strongly advising you to use. One is called the RLA CAA, the Listing Agreement Coronavirus Addendum or Amendment. I would strongly advise you when you take a listing, or if you're already in a listing, you get the seller to sign this. The seller, when signing this, agrees that they understand the risks and they're going to follow all the required orders and best practices. They're going to agree to the PEAD form, which is the next thing I'm going to talk about. And they're basically promising to do that. They're also on this form, you and the listing agent and the broker can decide between the 2 of you which type of pre-marketing activities are okay and which ones we're not, which type of so-called necessary activities are we going to agree to, or are we going to have inspections, all inspections, some inspections, et cetera, et cetera. Because even if something is permissible under the best practices, as long as you follow the best practices, some sellers are going to say, like, I don't care, I don't want anyone on my property except this guy or this guy, only home inspectors, no other inspectors. And I think the sellers probably have the right to do that in this situation. Of course, you're going to say, well, you're interfering with my ability to market the property to the best of my ability. I don't think that argument's going to wash in this environment if you ever have a problem later. The good thing about this form is when the seller agrees to this, that they're going to follow these best practices, then you're protected. On this form, they also say they assume the risk and they're going to hold the agent harmless for any, legal actions that arise out of this activity. And talking to E&O people and insurers, they're basically taking the position that if you don't follow these best practices, you do not have E&O coverage if anything goes wrong. So this form is not required, but it's very important, I think. And the form that goes along with it is something called the PEAD, the Property Entry Advisory and Declaration. And it says on the first form I mentioned, the listing agreement addendum, that the listing agent is, the seller is going to require anyone who enters the property to sign this form before they enter, which we believe is a best practice that's required. So this other form is the form, the PEAD form. You're going to not only have the seller and the listing agent sign it, but anyone who enters the property, buyers agents, and that should only be vacant properties, and other properties, anyone else is going to sign this form agreeing they understand the risks, they're going to follow safe practices, they declare that they're not sick, as far as they know, have had no contact with anyone who's sick, are not exhibiting any symptoms of someone who's sick. They're going to follow the rules, the safe practices. They're going to they've signed the form declaring that, and they also are assuming the risk on the form of any problems that occur associated with that. Once again, protecting the realtor, once again, protecting your E&O coverage. So everywhere, whatever county you're in, whatever city you're in, whatever restrictions that are in place, still as a minimum floor, the best practices is our legal interpretation of what the governor's order requires when you're doing real estate as an essential practice. You remember at the very beginning of this, in the entire state, real estate was not considered an essential practice. And we got that changed pretty quickly, but with these caveats that you have to follow these practices, okay? Now, next question is, I'm in a contract, I'm in a transaction, and in escrow, and then there are problems related to COVID-19. It's hard to get the lending, it's taken too long, it's taken too long to get an appraiser inspection, whatever. There are delays or things just aren't happening because of COVID-19. So one party or the other says, I have to cancel, or I can't remove my contingencies, or whatever. Whether you have, assuming you have no contingent offers, I can't close on time because of something that's happened, my health situation, my financial situation, problems with other people that, I just can't close on time. Therefore, I need an extension. And the seller says, well, you can't have an extension. And the buyer says, you have to give me an extension or I'm canceling, or just one side or the other cancels. And the buyer said, I canceled because of this COVID-19 situation. Give me back my money. And the seller says, I don't care. You didn't have a contingency. I'm keeping your money. So what happens in those scenarios? Does the buyer or seller have the right to cancel based on the situation we're in? Well, we have a couple of forms to sort of help with that, in that we got this one form called the Coronavirus Addendum, the CVA, which it's not required, but it's recommended that you attach this to your contract when you're in escrow or going into escrow as an amendment or an addendum, where the buyer and seller are sort of anticipating issues and saying, we both agree that if the buyer's ability to remove a contingency or the buyer or seller's ability to close on time is impacted so that they can't do it on time or at all because of something related to the COVID-19 situation, both parties agree that they will automatically agree to an extension. Or alternatively, you could check the box that they automatically agree to a cancellation or something like that. So you can sort of anticipate these problems and sort of have a form that you've already agreed to that sort of says what happens next. And we have another form that goes with that. This is the fourth form I'm mentioning. It's called the NUCC, the Notice of Unforeseen Coronavirus Circumstance. I'm the buyer, you're the seller, we're in escrow, we've signed the CVA form, agreeing that we'll have a 30-day extension if one of us can't close on time related to COVID-19. I, the buyer, experience a COVID-19 related situation that is causing me to delay. Since we've already agreed to the CVA, I submit to you, the seller, the NUCC telling him what happened, and this automatically triggers the automatic 30-day extension. Okay, what after 30 days after that? I still can't close. Now what? It says on the form that either one of us can cancel. Well, the question then is, well, if the buyer cancels in that situation, do they get their money back, or does the seller keep it? And you can indicate right on the CVA form which one it is. Of course, now you're thinking, well, the seller's not going to want to sign that form if they don't get the deposit, and the buyer's not going to want to sign that form unless they get the deposit back. Understood. Maybe your clients don't want to sign this form, which leads to my original comment. Forgetting this form, what happens if you're in escrow and the buyer says, based on COVID-19, I lost my job, I can't perform, I'm canceling, give me my money? Do they get the money back or not? Well, interestingly, there's a California Civil Code section 1511 that says parties to a contract are excused from their contractual obligations if there's an irresistible superhuman cause. Well, I wonder what that means. That's sometimes referred to as the act of God clause. But basically, if something like an earthquake or World War III breaks out, you could probably get out of your contract. Well, does this pandemic situation we're in right now qualify as some type of irresistible supernatural cause? Probably. We'll see how the courts interpret that. The advantage of using the CVA form is you can sort of at least preempt that a little bit, so you don't have to wait for a judge to decide, and you can sort of deal with it contractually. That may help. That may be a good thing. But the point is that that's the reason for those two forms. Okay? A couple more things before I open for questions. Another complicated thing we have in California now is new rules on rental properties. Throughout the state, cities and counties and the state have passed rules regarding evictions. Some cities have a rent freeze. Some cities are actually contemplating rent forgiveness. Probably won't hold up constitutionally. But the point is there's definitely eviction moratoria out there. I think Berkeley probably has one. Alameda County probably has one. The state of California has one. Which one takes precedence? They all take precedence. You got to follow all of them. For example, the California one says, yeah, if I'm a tenant and if I can't pay my rent this month for a COVID-19 related reason, you can't evict me for that reason. Of course, that only lasts till May 31st, and the tenant has to notify the landlord in writing of why they're not paying their rent and actually provide some verification of that fact. So to help you comply with that, we got the last two of our 6 new forms. The first one is called the NTAP, Notice of Tenant to Tenant of Ability to Pay Rent, of ability to pay. And the idea is this is a form of the landlord sends to the tenant basically saying, I notice you didn't pay your rent this month. You know, you're still supposed to tell me in writing why you didn't pay your rent and give me some proof of that, and it's got to be COVID-19 related, or I can evict you. And then the response form that the tenant can have to that is something called the RPD, the rent payment delay, where the tenant says, this is why I'm not paying the rent, here's the proof, this is how much I can pay, or I can't pay anything. And then, of course, it has a couple of good things for the landlord where the tenant can propose sort of a repayment plan. None of this is required, but it might help the landlord-tenant situation. Of course, the tenant does have to pay the rent back. An eviction moratorium means you can't get evicted for a certain period of time. It doesn't mean you don't have to pay the rent back unless you're in one of these cities. Some cities have actually specifically said you don't have to pay the back rent back for 2 months or 4 months or whatever. I have no idea. I'm sorry if Berkeley is one of those cities or not. But that doesn't mean you don't have to pay it back at all. although I did say a couple of cities are even contemplating that. I don't know if Berkeley's one of those. But then to complicate everything, to supersede everything I just said, Davina's saying stagers are not allowed. See, thank you for that, that local rule. Anyway, to complicate all of what I just said, the California judicial system, which is different than the state, the county, or the city, has said the the courts of California are basically closing down for a lot of things. One of the things they're closing down for are unlawful detainers, which would mean even if the tenant has doesn't pay their rent for some other reason other than COVID-19, or even if they have no reason not to pay rent, they have no financial hardship or whatever, they just don't want to pay their rent or something like that, you have the right to evict them, but you won't be able to through the court system. You can file your 3-day notice, but the court will not issue a summons. They'll not schedule a trial date. If a trial date has already been set, that'll be postponed. How long is this all postponed to? August 1st. That could change. But right now, no evictions until August 1st. So everything I just said is all in place together. I mean, any local rules, you got to comply with that. Any state rule, you got to comply with that. And as a practical matter, the courts are closed for unlawful detainers. They're closed for a lot of things right now. Not everything, but some things. And another thing that happened, you know, it's interesting. If you commit a misdemeanor in California right now or a low-level felony, you know what your bail is? 0. It's a good time to go out and commit a crime right now because they can't lock you up until they convict you. Then they can lock you up. Gov did not just say go commit a crime. I'm just saying. Anyway, so those are the 6 forms we've come up with. The first one, remember the RLA CAA, the recommended listing addendum you get. The PEAD, we strongly recommend you have anyone who enters a property in any capacity sign that advisory and declaration, and the seller and listing agent also. Third, the CVA, the coronavirus addendum, and the form that goes with that, the NUCC, the Notice of Unforeseen Coronavirus Circumstance, to help you deal with lack of performance issues in an escrow caused by the coronavirus. And then the last 2 are not mandatory landlord-tenant forms, the NTAP, the notice to tenant about ability to pay rent, and the RPD, the rent payment delay form. Other things going on, you may have heard, there's not just an eviction moratorium, there is a foreclosure moratorium, meaning most but not all loans right now cannot be foreclosed upon. Doesn't mean the borrower doesn't have to pay the money. It just means if you don't pay it, they can't foreclose on you right now. But that only lasts until May 17th if it's a conforming loan or FHA or VA, and until June 23rd if it's a direct loan with one of the big 5 lenders or the over 200 California lenders that have already agreed to this voluntary. Until June 23rd, we're not going to foreclose. But that doesn't mean at the end of that time you don't have to pay back all the money, because you do. So that's going on also. Things that realtors should know about, getting into more good news, is there are these programs that you can benefit from financially as a realtor that are brand new. And as I'll point out, the most important one probably is not even available yet, but it will be. The 3 things I want to mention, one are something called the PPP, Payment Protection Program. It's Small Business Administration, SBA program, federal money, but you have to apply through your lender, your local lender. And the eligibility you have is either as a business owner, you can get a loan to help you pay for any payroll expenses or mortgage interest or rents And it's the good thing about this loan is it's forgivable, which means you don't have to pay it back. You just have to use the money by the end of June. And of course, they allocated $349 billion for this. It's almost all used up. So the president has already said he'll agree to more funding. Congress hasn't yet agreed to that. And independent contractors, you guys can also apply for these forgivable loans under the PPP. You're gonna have to prove your loss of income. There's a process. You're gonna have to deal with your individual lender with their application, but there'll be a way to you access these funds as well. If you have any questions on this, don't ask me, I'm not the expert. Ask our COVID relief hotline. We have experts, 12 of them, waiting for you to call right now at 213-351-8450. But ultimately, it's going to depend on, you're going to deal with your individual lender for that. Another program, an alternative program, is something called EIDL. I always forget what that stands for. I got to look it up each time. Economic injury disaster loans. Let's say you're a business owner and you're thinking, you know, I'm going to have money. I've lost revenue and I have debts to pay and payroll to pay and interest mortgage to pay and accounts payable to pay, and it's going to go beyond July 1st. Rather than a forgivable loan, it's better for me to get a low interest long-term loan that I can use beyond July 1st. And that's another option to have. And this program also, you might be eligible for a $10,000 grant. So you're going to figure out what's better for you if you qualify, the forgivable PPP or the grant plus not forgivable long-term low interest loan. Feel free to call that number I gave. It can help you with that. Talk to your lender, talk to your accountant. The third option may be the best one for a lot of you, and that is the Pandemic Unemployment Assistance, PUA. Yeah, I'll post that phone number in a sec. And I'll say it one more time, 213-351-8450. By the way, if you go to C.A.R.org, your website, the first page, there's a link to it right there. The phone number's right there. There's a link to the microsite we have for the coronavirus, car.org/coronavirus, or you can just link to it on the homepage of the C.A.R.org. But anyway, the PUA, the bad news is you may have all got an email yesterday from the California Department of Labor, EDD, saying, you know what, we're not going to be ready to do this for 2 more weeks, which means I hope they're ready 2 weeks from yesterday to start processing these pandemic unemployment assistance loans. The good news is you guys as independent contractors are actually eligible for this, whereas normally independent contractors are not eligible for unemployment. This is a special unemployment that you are eligible for. And even though there's been a delay rolling it out, it's still going to be retroactive back to January 27th, and you'll be eligible for 39 weeks at least of $600 a week. So that might be, for some of you, the better option comparing these programs, which is you're going to have to sort of figure that out. But we do have people to help you. If you don't call today about the PUA as far as the details, because the application is just not ready yet. But you can talk about the general features of it. Feel free to do that. But those are sort of the big 3. Plus, a lot of people are supposed to be getting a tax rebate of $1,200 plus $500 for kids. You also get a tax credit for any unpaid sick leave you've had to take. And business owners get a tax credit for that too. So there's a lot of going on. It keeps changing. I spend half my time reading stuff that just changed to try to keep up with. On our website, we have a chart, a spreadsheet. You go to the coronavirus microsite, car.org/coronavirus, the right-hand side, you can check a box that says local ordinances, and it has for every city and county that has a local ordinance, what the local ordinance is regarding the rules for stay at home. And it also, if you have a question about any of these landlord-tenant rules, there's a lot of information on the website, or just call the legal hotline and we can help you with that. Sometimes you guys know more than we do about what's happening exactly where you are. And I know Berkeley is traditionally a very strong tenant city, and you probably have local things I haven't even heard of. So I'm giving you the big picture and the overall view. I just saw a question from Tammy real quick. Yes, the first 4 of the 6 forms I mentioned are being tweaked and will be released Friday, the updated versions. Not dramatic changes, but I think all positive based on the feedback we've gotten from you guys about the use of these forms, because they were rushed out in a real hurry. But that is going to happen. There's going to be a webinar at 10 o'clock Friday morning, which you'll all get an invitation to, that will be recorded, going over these forms, the updated versions like I just talked about. So that was a mouthful. You can ask me questions, however you want to handle it. You can call on people. I can look at the chats, whatever you want to do.
So if at the bottom there is, if you click on participants, you can actually click on that and then raise your hand, or you can unmute yourself and ask questions, whatever anybody wants to do. Robin?
I think Davina, you ought to call on people though, right?
Yeah, I do.
Okay.
Got Robin. You can go ahead and unmute yourself. I saw your hand go.
Hi there. I asked this in the conversation in the chat room, but with the PEAD form, if I have a service provider, like a carpet installer, the company signs it, but do I have to have it individually signed by the installer?
Yeah, we think the best practices actually requires that. In other words, anyone who enters.
Okay,
And,
thank you.
And if they enter today and go back 2 days from now, make them sign it again. As far as the seller, I don't think you got to sign it each time, but you got to sign it at least every 14 days, because you're basically saying on the form, you haven't had any symptoms for 14 days or whatever. So that could change too. So it doesn't hurt, but yes, anyone who enters the property should sign it each time they do enter the property.
Okay, so our company has an individual form for that, asking a series of questions, as well as the PEAD. So both forms need to be completed by anyone entering the property, correct?
Well, obviously haven't seen your form. Maybe your form, in other words, would satisfy. Remember, C.A.R's, what happened was the governor issued the shelter-in-place order, and then he changed it to allow real estate, as long as real estate people followed the best practices that are required by health officials and the CDC. We took that and turned that into our best practices form, and actually turned our best practices form into the PEAD. So we're going to say following the PEAD means you're in compliance. Now, maybe your company is even stricter. Maybe it has some different things that weren't addressed. So it's probably a good idea to have both, I'm thinking.
Thank you. Okay, thank you.
Thank you, Robin. Any other questions? If you can raise your hand, or let me see if I see anything.
I'm starting to look at the, okay.
Anybody else? Well, I think there was a question in the chat from Brooke, and she says, if you're an employee part-time still, can you claim unemployment as an independent contractor since real estate is a primary income? It looks like she has a part-time position as a resident manager.
Yeah.
For the building.
In other words, you'll be able to get both regular unemployment for your W-2 job, and the other for your 1099 job. By the way, I'm reading from Steve Pierce, who says that Alameda and Berkeley clarified that inspectors, appraisers, photographers, movers, and other essential services may enter occupied or not. See, I was suspecting that I'm glad that's the way they broadly interpreted that language, to say that it's not everybody who can only enter. It's just, as far as the only vacant houses, that's for showings to buyers. Then Lori asked about stagers. Corinne says stagers are not. Steve Pierce agrees stagers are not. Thank you for educating me here about stagers.
I have
Lisa
another one.
Uribe, yes, the forms are not required, but recommended.
Yeah.
If you want E&O coverage, not to melt and be safe, yes, use the forms. What about renters in a unit? That's a very good question. What if you have a tenant in the property? Can they not cooperate? Well, they can not cooperate because by definition, if there's a tenant there, it's not vacant, which means showings aren't permissible. So the tenant can say, no showings, you can't come in. Okay, well, what about inspections though? So it's not a showing. Does a tenant have to have an inspection? And as it was noted above, they can, as long as the occupants leave the property 30 minutes before the inspection, return no less than 30 minutes after. Great. Or you can say to tenants, you got to leave for 30 minutes and come back 30 minutes later. What if the tenant says, no, I'm not leaving. I don't feel safe. No, you can't come in. Well, what is your remedy against that tenant? Well, you can evict them, but remember what I just said? You're not going to evict them till August. So I guess you can basically give the tenant incentive to cooperate by saying, hey, if you interfere with this, you might cause us to lose this sale. Losing this sale is going to cost us money. We're going to hold you financially responsible. We're going to sue you for the damages caused by your refusal to go along with these inspections. Like I said, I don't think they have to allow showings, but I think they have to cooperate with inspections. But what if they don't? As a practical matter, you can't evict them, right? Steve Pierce is also telling us stagings must be virtual. Yes, that follows along. Yes, the more strict one always applies. Oakland, yeah, it probably has a very strict rule. You can never evict for non-payment. What does that mean, Elizabeth Watson? That you can never evict for non-payment? I mean, they don't have to ever pay them back? Is that what they're trying to say?
What the Berkeley's, I mean, Kieran and I have been following this, and Kieran may have some thoughts, but Berkeley side reported that you could never be evicted for non-payment of rent if you were unable to pay, if the rent is related to your ability to not pay it during this time.
Now I understand.
Can't force, essentially what the Berkeley side report, I read it and I didn't understand it this way, but I'm not a lawyer. Kieran is. But the Berkeley side reporter said, that their understanding was that Oakland said, you can never be evicted. So basically you'll never have to pay it back, essentially.
Yes, and remember, I think I mentioned in my remarks that some cities were contemplating that, and apparently Oakland's gone further perhaps than contemplating and actually tried to enact something saying that basically they're saying the rent is forgiven.
So Oakland's law says that if you cannot pay rent during the emergency, during the local emergency due to COVID-19, then you cannot be evicted for that reason. So even after the emergency is over and you still owe that debt, you cannot be evicted for non-payment of that rent during that time. But you could seek payment in small claims court as consumer debt. So
right. Good point. Thank you. So in other words, not a clear forgiveness, just you can't use the remedy of eviction. I know for a fact that the San Jose, because we're tracking these things, the San Jose City Council actually was debating the other day actually forgiving that rent. In other words, you couldn't even sue, in small claims court as a debt, much less evict. So we're going to be tracking that because I think that we would argue that that's just violates the Fifth Amendment to the Constitution, the taking without compensation. As to the Oakland rule that you can't evict for that, but you can still sue for damages, that's, without thinking too carefully, that's probably constitutional. Thanks for educating me once again. And Karen, you also point out about tenant harassment laws. I mean, that's a great advice to give in this situation, especially in a city like Berkeley. Get a lawyer before you do anything in this area. Anna Frankel says, if a seller doesn't provide a PEAD form, will we still have the buyer sign one? Yes. Even if the seller's not going to cooperate, I think you should have the buyers sign it. I mean, what if the buyer shows up to the property without one? Hopefully you as a seller listing agent are prepared for that and have your own form there. But thinking about that comes up. What about vacant
property there?
Pardon? I'm sorry?
But we're not supposed to be there if we're the listing agent.
Right. It's hard. It's going to be hard to manage this. That's a good point. Although I'm not so sure you're not allowed to be there because it says showings no more than one agent representing the buyer and 2 other people. It doesn't really mention the listing agent. And but you're right. I think that the conservative interpretation of that is you aren't supposed to be there. I guess you could be outside handing out forms. You know, good question there. Let's see here. Let's see anything else. Painters, handyman, flooring. Do any of you know, are there any specific Berkeley rules addressing painters, handyman? I'm saying if it doesn't say specifically, then it would fall under that general rubric of service providers that enable transactions. Cleaners to
painters, roofers, they're not allowed, and Karen, correct me if I'm wrong, but they're not allowed unless it's for the betterment of the property to keep it to be safe. But
Right.
Sanitary, and probably sanitary, safe and sanitary.
Habitability, maintenance, anything aesthetic, cosmetic is not allowed.
Well, I'm glad that your city has at least clarified these things, because in a lot of places it's wide open to interpretation. Inspectors are sort of mentioned specifically most places, so that's good. But yes, other places I have heard have the health and safety, security, or sanitary exception to that. I'm glad you guys are really keeping up on this, because a lot of places I talk to, they don't even keep up on their local rules, and you guys apparently are very well. Thank you for doing that. That's good for you, because yes, you have to follow the local rules, the county rules, and the state rules, and they keep changing. And up until like 3 days ago, the city of LA allowed no showings even of vacant properties. So they're so happy in city of LA that they can at least now show vacant properties. A lot of places still allow all showings. Some places allow no showings. One county actually went to the trouble of passing an ordinance that says specifically real estate is not essential. You know, can anyone guess what county that was? It was Trinity County. But so anyway, it sounds like you guys are up on this more than most of the people I talk to, which is good. I always say that when I come to Berkeley, you guys sort of know what you're doing up here. And look out for the tweaks to the forms that are going to come out Friday. They're not going to be that big of a deal. More protection, I think, more stuff that attorneys thought we should put in there, which you'll find helpful. And no other forms are currently being planned to come out specifically to deal with this situation. The big news is the PUA will be available hopefully in 2 weeks. I don't know of any other big changes along those lines. Hopefully things are going to calm down a little bit as far as stop changing every 5 minutes, but I wouldn't count on that. Plus now we don't know, things may start gradually to open up. So some of these ordinances we've been talking about may change. You guys are doing the right thing by going to meetings like this and checking the website. And that's all we can all do, I guess.
Well, Gov, we thank you so much for coming today. And
My pleasure.
is if things continue to change or whatever, we might have you come back again. Thank you everybody for attending, and we went a little bit over our time. We were trying to keep it to an hour, but you know, so much information to give you, and Gov is always great. I'm including my email address below, and I know my staff has included theirs. If they can one more time blast it into the chat, please do so. My staff is working regular business hours Monday through Friday, both on the MLS side and the association side. All my staff is here to help you. Again, watch for updates as we send them on. We are here for you. We will continue to have training classes and everything here for you, and we are working for a support. Thank you again, Gov. Please, everybody, stay safe, stay healthy, and if you need anything, please reach out. Thank you very much. Have a wonderful day, everybody.
Thank you, everyone. Thank you, Divina.
All right,
Thank
thanks,
you very
Divina.
much, Gov.
Thank you so
My
much.
pleasure.
Thank you.
Thanks, everyone. Thanks.
Thank you. Take care.
Thank you, everyone.
Thank
Good
you.
to see everyone. Stay safe.
You too.
Healthy.
Thanks. Bye.
Bye.
Thank you. Bye.
Bye.